Greetings and welcome. I'm glad you are joining us today for Physician Contracting 101. In this series, we are going to look at what you need to know as you receive and review your employment contracts with either a hospital or a hospital provider or other physician group. This is a 6-part series in which we will take a closer look at some of the important contract provisions and how they will impact you and your future as you work through those employment agreements. My name is Paul Drey, and I'm an attorney with the Gentry law firm in Des Moines, Iowa. In my practice, I work a lot with physicians and physician groups, and as part of that practice, I review a lot of contracts for those doctors and for the physician groups themselves, and work in the drafting of many of the provisions included within those. Today's session that we are going to look at is really important in the sense that more and more physicians are becoming employed by hospitals or other providers. There's a number of national trends and reasons why this is so, but the trend is obvious in that physicians are looking to employment as a viable option for how they will conduct their business in regard to the physician practice. Today's series is divided into 6 parts. This first series is going to look at closely the employment contracts and some of the key provisions within those contracts. In the second of the part series, we are going to identify some of the key negotiable terms and also begin looking at which of those terms are most important. The first provision we're going to look at is a provision dealing with the duties and responsibilities of the physician. In part 3 of this series, we are going to discuss compensation and benefits. We're going to take a closer look at those 2 issues just because they are so important and really are key to whether you're going to enjoy your practice or not. Fourthly, we're going to look at the provisions of a buy-in and also the professional liability insurance that may be protecting you as you conduct your work. In the 5th part of the series, we are going to look at non-competes and termination provisions, which are also very important in your contract maneuverability as well as in how you come into or how you leave the contract that you are working on or within. And finally, the 6th series is going to look at the other provisions within an employment contract and why they are important and how they can be really important to your future. So let's begin today as part 1 and looking at some of the key employment terms and provisions within your employment contract. Some of the key terms or provisions that you will look at are the duties of the physician and how they are outlined. You're going to look at the qualification section, which sets forth what are your qualifications, and you're going to need to make sure that you meet each and every one of those as you are repping and warranting that they are in fact true and correct. Another key provision is the term provision, which sets out and outlines for you how long the contract is actually going to last. Is it a 1-year contract, a 2-year contract, a 5-year contract, and what are the renewal terms and how does that occur? The 4th term is in regard to compensation and benefits. A 5th key term is in regard to medical records and filings and who they belong to and how do they get done and made and what are your responsibilities in making sure that they are done in the way the hospital or your employer desires them. We are also going to look at buy-in provisions, i.e., do you have an ability to buy in or become part of a practice? Typically in a hospital setting this won't apply, but if you are looking at an employment agreement with a smaller group or physician group, sometimes you will have the option of whether you want to buy in. And that's a key provision as to sometimes your successful continuation or future within that practice. We're also going to look at professional liability insurance and the different insurance policies and way that you can protect yourself in the unfortunate event of a malpractice case. We're also going to look at non-compete provisions, which are essential to or which are often included within a contract, but which can be quite onerous. And so we will want to look at how can you work with these non-compete provisions and how can you make sure they are limited so that you do not keep yourself from practicing in the future. We're also going to look at entire agreement provisions and other provisions within the contract that may affect and impact your employment situation. Again, I'm reminded, and there's a slide that you're going to be taking a look at in regard to a woman sitting and it says, I'm trying to decide on a healthcare lawyer. and as she's deciding, she's pulling petals from a flower. The image is quite telling in that oftentimes physicians, I think, fret over the decision not only on the contract, but on how they're going to review that contract. I think it is key that you look for a healthcare lawyer who knows and understands what the impacts are of the contract you're reviewing. Not any lawyer can do this, and I would recommend highly that be a lawyer who is very familiar with the healthcare industry and the provisions within the healthcare contract. Some of these provisions look like any ordinary business contract, but in reality, they are quite significant and quite specific to your profession. So having the right attorney to review those contracts on your behalf and to protect your interests becomes vitally important. Thank you for joining part 1 of our series.